Great. Thank you, Sean, for starting the recording and for helping us on the technical side of today's session. It's very much appreciated. And welcome everyone to ArbTech's session on esports. We will be talking about what kinds of disputes arise in the gaming and esports industry and how they can be resolved. So as you have seen, the session is being recorded and it will be made available via our website, where you can also find recordings of some of our previous sessions. We have held sessions on various topics on the intersection of technology and dispute resolution, and I will share the link to our website and to our LinkedIn in the chat shortly. Today, we are privileged to have with us an amazing panel of experts on the topic of esports, and I will start by introducing each one of them briefly. First, we will hear from Leonid Shmatenko, who is a senior associate at Eversheds, Sutherland. He is part of the firm's data protection and technology law team. He has vast experience in regulatory and general issues in the areas of esports and blockchain. He advises esports associations and teams on all legal issues, and he also advises and supports crypto startups in all matters from planning, preparation to execution of private and public token offerings, so-called initial coin offerings. And furthermore, he specializes in international arbitration and has participated in several arbitration proceedings under the rules of the Swiss Arbitration Center, the ICC, the German Arbitration Institute, UNCITRAL, ICSID, as well as in ad hoc arbitrations. And he has acted as both a party representative and secretary of the tribunal. For the second part of today's session, we will have Alexia Gkoritsa and Oscar Suarez from WIPO, the World Intellectual Property Organization, who will walk us through WIPO's work in relation to gaming and esports. So I will first introduce Alexia, who is a legal case manager at the Business Development Unit of the Arbitration and Mediation Center of WIPO. She holds an LLB from the School of Law of the National and Kapodistrian University of Athens, Greece, an LLM in Civil Procedure Law from the same university, and an LLM in International Dispute Settlement, the so-called MITS LLM, which is provided jointly by the Geneva University Law School and the Graduate Institute of International Development Studies in Switzerland. Prior to joining WIPO, she worked on international dispute resolution, ADR, corporate and commercial law, EU competition law, and intellectual property issues in the private sector, as well as with the Competition Authority of Greece. And last but not least, let me introduce Oscar, who is an associate legal officer at the Arbitration and Mediation Center of WIPO. He is a Colombian lawyer with an LLM on international civil and commercial law from Leiden University in the Netherlands. And before he joined WIPO in 2018, he worked for several years on corporate law, international trade, and intellectual property issues at private sector companies and law firms. He has also been part of the Digital Assets Project Research Group at the University of Oxford, which studies the legal and regulatory aspects of new digital assets such as crypto assets, DLT technology, NFTs, and ADR. His work at WIPO consists mainly of handling international arbitration and mediation cases and assisting WIPO member states in developing and implementing ADR policies and systems related to IP and innovation, with a focus on copyright and content-related disputes, including the digital environment. Now, before I give the floor to Leo for the first part of the presentation, I would just like to go over some housekeeping issues. We have up to 1 hour for this webinar, and as usual, we have reserved some time at the end of the session for questions and a discussion. But don't hesitate to already put your questions in the chat as we go, and then I will either read them to the speakers at the end, or you will have the opportunity to unmute yourself and ask them directly. And I will also monitor the chat as we go during the presentations. So if there's anything that I see should be addressed at the time, I will raise the question. And with this, let's get started. And Leo, the floor is yours.
Hello. Thank you, everyone. Thank you for inviting me. Thank you, Elisabeth. Thank you, Sophie. Thank you, everyone. Glad to be here and presenting on that really nice topic about esports disputes and what do they look like and how we resolve them. I will guide you through a short presentation where we can jump already to the next slide. And see which legal problems we have in esports. But before that, I will also give you a small overview over the distinction between esports and competitive gaming, because not everything that is competitive gaming is considered to be esports. For example, if you're candy crushing on your tram ride every morning, then you can be for sure a competitive gamer. But if you want to be an esports athlete, then it has to be a game where you compete live against a different human being. So, if, for example, FIFA, where you play football against each other. So esports is only competitive where you play at the same time, but competitive gaming can be speed running and other disciplines. So I will jump forward from the disciplines that we have in esports, such as first-person shooters, strategy games, and so on, just to the problems, so we can have more time to discuss the disputes and what problems we have at the moment. So in esports, we have different legal problems that go hand in hand, so to say, with the traditional sport problems. That is doping, which is taking substances that enhance your capabilities, be it concentration, and so taking Adderall or Ritalin or other drugs which can be prescribed. Then we have cheating problems. When people cheat within and they modify the source code, or they modify the game so they have an unfair advantage towards other players during the game. We have match fixing problems, like for example in football, where you can bet against or for a team, and that team colludes with the one who's betting on purpose losing the match. But we also have labor law issues, because at times there are minors who are employed by the teams who are professional esport athletes and that do not get paid and want their money or their prize money or their sponsorship money. We have visa problems, and we have problems also, for example, if somebody wants to create club, an esports club, how to create an association, how to get a non-profit status if it's not a for-profit club, and so on and so forth. So all these kind of legal problems can lead either to disputes in litigation or in arbitration. But since we're here in ArbTech, we're going to concentrate on the alternative dispute resolution, being mediation, arbitration. So next slide, please. As you see, I have cut out a few headlines from different journals on esports. So doping in esports is a problem that is currently being tackled by ASIC, and we will address that at a later stage of this presentation and my presentation, that people really try to get an advantage, and they get disqualified during professional matches, which can again lead to disputes, as you have seen, for example, in the Olympics, where the Russian Federation team has pursued different arbitrations against the international athletic federations and other federations where Russians were disqualified due to doping. Next slide, please. And then we have cheating, which can have different forms of exploiting, for example, some kind of bug in a game, or for example, entering something that you can see through walls, for example, here. And you can start the video, and I will keep talking during the video. This is a video from Counter-Strike, from the new beta of Counter-Strike Global Offense 2, where it is possible to activate a so-called wall hack. And if you could stop the video for a moment, you will see that there are green. Yeah, if you go back a little bit. Yeah, you can see on the white background that there are green squares. That means that this is the player which is behind the wall, a different player than the one who is playing. So he sees the player through the wall hack before he sees him on the computer screen. So he can tactically move in a way that he will know that his enemies are over there, or like here where we go forward in the video, that they're behind the door, and for example, like he's doing, throwing a frag grenade inside, getting an advantage over the other players. So this is being called wall hack, and there have been scandals in Counter-Strike, which is one of the competitive gaming. You can stop the video, we don't need to go further, where teams have been disqualified for that behavior. And this is certainly a point which can lead to disputes and to also banning the teams from different competitions. The problem that we have in esports is that if somebody is cheating, for example, or doing that wall hacks in Counter-Strike and will be banned for all Counter-Strike tournaments, that does not mean that he can use his knowledge and expertise and know-how of how to play first-person shooters, for example, in a different first-person shooter, such as Valorant or Overwatch, which is basically dying in the esports community, but anyway. So this means that there is no centralized register that an athlete who has doped or has cheated in his previous career will not be banned from other tournaments. And we can go to the next slide, please. And come to another problem, which is match fixing. So this also led to different scandals in the esports scene. I'm gonna shorten it a little bit. For example, in South Korea, where the real-time strategy game StarCraft 2 is very famous, some players have colluded with a bettor and lost on purpose. But since in South Korea, esports is acknowledged as a discipline and there are a lot of regulations, those players were A, sentenced by the criminal code for match fixing, and B, banned for any kind of tournaments in esports. So this is something to consider. Next, please. And what do we have from the regulation bodies? Who can and what can they do? We have ESIC, which is the Esports Integrity Commission. It was founded in 2016, and they are something like the WADA, like the World Anti-Doping Agency in the esports business. And what they do is they take responsibility for the disruption, prevention, investigation, and prosecutions of all forms of cheating in esports, including but not limited to match fixing and doping. So all these problems are the ESIC is trying to solve. However, the ESIC does not have a mandate for all tournaments. It only acts where the tournament organizer, and this is only one of the stakeholders in esports, concludes an agreement with the ESIC. So only tournaments where you have it in the terms and conditions that you might be subject to a doping test, they will be controlled by ESIC. But ESIC is doing quite a good job. They're really enhancing their work. And then again, once they issue a decision, there is no way to dispute it. There is no kind of body, of a judicial body like the Court for Arbitration in Sports to review that decision. So that means there is some need. And I have been talking to different stakeholders in the last days who stressed that, yes, we need an arbitration court or a mediation in esports to solve a lot of disputes. Next slide, please. And then we see, this is an overview over the dispute resolution mechanism in the different competitions. For example, in StarCraft, the arbitration clause of the World Championship Series refers to jams in the US. The FIFA Interactive World Cup, on the other hand, refers to the Swiss rules of international arbitration, of the Swiss courts of arbitration now, and the Sky, as it was called before. I have searched, it has not been updated, even though the administration body is called different now. So if we can turn to the next slide. We have also players underground, so PUBG mobile esports, which refers to the Hong Kong International Arbitration Center. And then we have Swift. Swift is a cycling simulator, which is quite popular also amongst professional cyclists who are doing the Tour de France and so on, which is just digital, and you use your real bicycle, your real racing cycle for this kind of competitions and so on and so forth. And Swift has a JAMS referral, but it also has internal commission for disqualifying players for cheating and other violations. And if we can go to the next slide. Then we will see that in Call of Duty, there is an ICC reference in the arbitration clause. And then the last one, which is really, really long, I just wanted you to see it. And I don't know whether the hosts will send to the presentation, but I would share it with you. You will see that the League of Legends European Championship has a dispute resolution clause, which does not refer to any kind of known arbitration institution, but just has some rules to resolve the disputes within a short time frame. So if we go further with the slides, we will see that there were some attempts to establish an arbitration court. The WESA, the World Esports Association, which is related to the Esports League, which was recently bought by Saudi investors, has an arbitration court, but that arbitration court refers only disputes within the ESL championships to arbitration. It is not known how it was founded in 2016, and it's not known how successful it actually is. I've heard of something like 6 cases that were administered there, but never again. Then we had the WESCO, Court of Arbitration for Esports, with an appeals instance at the CAS. It does not exist anymore. I have been checking the link today. It's gone, so it's not there anymore. And we had a mediation effort by MK Mediation, which was a law firm in Canada. But again, this was proved also not to be successful. And then we have the initiative of the WIPO, which I'm sure my colleagues Alexia and Oscar are going to talk about. So I'm going to spare you of this. You will have much more experienced people talking about that. Next slide, please. So why do we need a court of arbitration in esports? Is because federations, for example, I have talked to the German and to the Swiss one and to the Austrian one. They're saying we have different players, esports athletes, who are concluding contracts with, for example, football clubs, and we have organizers of tournaments. We have a lot of stakeholders. We're saying we do not have one court to go. We have a really splitted jurisprudence. We have no people who are knowing what they're doing. If we go to a court, the people do not know what esports is about, and then they think it's just a game between 2 nerdy people, and they do not rule quickly enough to resolve the disputes. And the pros of having a court of arbitration for esports is that all esports related disputes would be solved in one place, and this is what the CAS has achieved and what the Basketball Arbitration Tribunal have achieved, that you have a body of case law referring to one special thing that will be useful for future disputes. And so that could help solving the fragmentation in the esports and bundle the community in one place. Next, please. But we're facing a lot of challenges on establishing that kind of arbitration court. The esports scene, as you have seen from the previous slide, is very fragmented. You have, on the one side, you have publishers who are the IP holders of the game. They're organizing tournaments and leagues, and they have a franchise system. And then you have tournament organizations and organizers who are organizing tournaments, getting licenses from the publisher. Then you have federations which have their own interest of getting all the clubs together. Then you have the player, the athletes, and everyone has a different interest. So the challenge for the esports arbitration court is to cover these interests of all stakeholders without with the best compromise, so to say. And it must be fast, because I have spoken to everyone or to many people in the esports community, and everyone is saying that we don't want classic arbitration. We want online dispute resolution. We do not want to wait for our award for ages. We do not want to spend a lot of money on that. We want to have, if we have a dispute, we want to file the statement of claim or the notice of arbitration in a really short time frame, have the hearing right after it, and the answer and so on, and have the award within days. So this must be really quick. And everybody wants esports enthusiasts who are doing that, and not just random people who do not have a clue about esports. So there are a lot of challenges that we need to face and to surpass to establish an esports arbitration court. Next slide, please. And then there are some cases where, for example, in Germany, labor disputes are not arbitrable. So mediation would be an alternative here. Next slide. So I tried to speed it up in the end for your questions, and I think I'm anyways a little bit over my time.
Thank you so much, Leo. That was very, very interesting. If anyone has questions, we can take some questions now. Otherwise, oh, I see that James has written a question. James, do you want to unmute yourself and ask Leo directly, or?
I've seen
Yeah.
the question of James. It's, do esports arbitration providers raise awareness of their existence through in-game advertising? No, they don't. And I think that is also not very compatible with some of the ethics laws of in some jurisdictions. But I'm sure that once an esports arbitration court will be established, there will be a list of such arbitrators, so everyone can look inside and find his or her or theirs arbitrator of whichever gender.
Thank you so much. You're obviously very knowledgeable. I really enjoyed your presentation. In the interest of time, I suggest that we move to Oscar and Alexia, and then hopefully we will have some more time for questions at the end. And again, please, if anyone has questions, don't hesitate to already put them in the chat as we go. The floor is yours, Oscar and Alexia. Thank you.
Thank you so much. And thank you, Leo. That was very interesting. I have to say that times have changed dramatically since I was playing Nintendo 64 and waiting for the Nintendo magazine to give me some cheat codes till now. So fortunately, I'm not a competitive player, but it was super interesting. Thank you everybody for the invitation, of course. Elisabeth and Sophie and the people of ArbTech. Really is a pleasure to be here with my colleague Alexia, and also with Leonid, that we are quite in touch with. Can you hear me okay? Yeah, oh good.
Yes.
So, okay, perfect. Let me see. There's just a little problem with Alexia's Zoom, so let me just jump to my presentation very quickly from this side. There's no issue.
Thank you, Oscar. Sorry,
Yeah,
my
sure.
Zoom just crashed.
Sorry, give me just a little second, and I'll open the presentation from here. But just to say that today the idea is to complement a bit what we've been discussing on the sidelines with Leonid and this project that we've been developing. I will share my screen right now. Let me know if it works.
I think
Give it a
mine
little
works
second.
now, Oscar, if
you
you
try
can
it?
see it.
Do you want to try it out?
I can see Alexia's screen, so
Perfect.
I
Yeah,
think
me
it's
too.
Okay.
working.
Great. Okay, great. So we're all set. So as I was saying, what we're going to talk about today is what we're doing at WIPO, particularly focusing on esports within the bigger umbrella of video games. So it's a big area that we're exploring. Of course, we know that the video game industry has grown massively. Particularly, there's been a big focus on the past years. Of course, the pandemic has helped. So in this sense, I'm going to explain a bit what we do from WIPO. And I think for the sake of the argument of why we are focusing on esports, I'm going to give a brief overview of why we focus on specific sectors. I think that's part of a conversation we had when we were planning this conversation today, is why we end up like looking into specific sectors for ADR. And then Alexia will have the rest of her presentation to give us the insights on what we are doing on video games and esports. And then of course we will be very happy to answer the questions you may have. So first of all, the WIPO Arbitration Mediation Center, of course, is within the World Intellectual Property Organization. We are based in Geneva. Of course, our focus is to promote innovation and basically through a balanced and effective international intellectual property system. You may know us for different conventions and treaties, and especially for the registries we have for patents, trademarks, and whatnot. But what we've been developing from being part of the UN, it's different focuses, particularly helping more the private parties that are actually using the IP system. So in this case, we are within a sector that has the IP and innovation ecosystem, where we're basically trying to figure out how IP is relevant for the different actors in the system. And of course, video games, esports, it's completely within the realm of IP. Basically, when you're looking at any video game, you have so much IP going around. So this project of esports goes hand in glove with all these projects. So what we do from the Arbitration Mediation Center is we focus, of course, on IP and related commercial disputes in the different specific sectors that I'll explain later. But I think, and for a bit to complement what Leonid was saying, is like, as a provider, we have this standing is a bit different from other ADR providers, that we're part of the UN because we're a specialized agency of the UN. So that gives us a very particularly neutral approach. And of course, because our mandate is IP, so we're very specialized in not only IP, but the business areas that surround IP. So that allows us to go into a bunch of domains that I'll explain a bit later. We focus, of course, end users all over the world. We have cases from Latin America, Asia. We have offices in Singapore, a bit all over the place. And we see cases coming from very different IP-related industries. And we are starting to see more and more things related to video games, to esports, and having these kind of discussions. And I can really assure you that we have seen a real increase in the interest and use of these ADR systems, particularly, and I'll make a focus on that, but Alexia will talk about it more in detail, on how maybe mediation could be a faster way to consider, at least even for the sake of arbitration, to kind of actually nail it where we want, where the dispute is about. And actually that will, in the end, reduce the time and costs of arbitration in the end. So in the next slide, you will see a bit where we are, what we're doing, the caseload that we have. The broader message here is that we are completely global. We have, of course, cases coming from all over the side, all over the areas of IP. But when we're talking about video games, when we're talking about esports, all these legal areas are involved. So we have patents and from the hardware that is used to copyright, the storylines, the characters that are all over the place, the trademarks that are registered, not only in the games per se, but the competitions that you need licenses to be able to have this trademark. So we were seeing all the cheating problems within the esports, but the approach is broader because a lot of things can be brought within the realm of ADR in this particular area. So in this sense, we just show that we have a particular a specific focus on cost, on trying to find settlement instead of awards, unless of course is needed for different reasons, like a consent award, for example. But also we have a diversity of languages that comes from the fact that we are UN. So this is my message here. And then on the next slide, I also wanted to show you a bit that our collaboration, of course, goes with private parties, but also these are things that are, as WIPO, as the organization, we are working with a lot of the IP offices around the world, discussing these particular things, copyright in a broader way, but also all the digital environment and digital content in general, which means video games. That's basically what I'm trying to say, and esports as a fact. So after all this very broad and quick explanation of what we do, I wanted to explain a bit why ADR and then why we go into this and into the specific areas. And of course, I want to add to what Leonid was saying, and is that we have been having these conversations, is that ADR seems like a very good fit for the needs of the esports industry, and particularly because, at least from the WIPO Center, everything is digital. So we basically, even all our arbitrations, we could say like maybe 90% of our cases are completely digital now. Parties parties prefer just to connect as the way that we're doing today and try and solve the disputes. I personally have administered quite some arbitrations that were completely digital, and parties just basically pleaded using the different platforms that are available or the ones that we provide. But also, we are non-for-profit, so we are very flexible with the fees, because we're basically just trying to help the IP environment to unlock the disputes and just move forward, and that for the users too. We also are focusing a lot on mediation, and we have adapted, for example, our rules to the provisions of the Singapore Convention, trying to be a bit ahead of the game in case the convention starts gaining traction, as it's been gaining traction in the past years. And of course, there's a couple of things that are relevant here. Is the confidentiality, which sometimes is quite important, especially for reputational issues. So I think that fits hand in glove with some of these, because these are very public events. So many of the times what we need is a confidential environment, and that is one of the main characteristics that we have, and everything. And when we will mention some cases, it will be all anonymized. On the next slide, we can now focus a bit on well, Alexia will explain a bit more mediation, arbitration, expert determination. These are basically the procedures we work on. We won't go into full detail. Just depending on the audience here, we just make it very clear that these are all voluntary procedures. And that's something that we do quite clearly, because sometimes we are confused as the IP police, and this is not the case. Everything that we help solve here is based on voluntary mechanisms, as mediation, arbitration, expert determination, based on clauses like the one that Leonid was showing us a bit earlier. So why specific sectors? And I'll take a minute extra, and then Alexia, I'll let you go into the interesting part of the presentation. So basically, it's trying to take these 5 considerations and saying how we can save time, how we can acknowledge that IP, it's basically convention, like international treaty based. So it has a vocation of being international. Parties are everywhere. And in the video game environment and the esports environment, well, this is actually a fact. Like, and thinking about when I started playing video games back in the day, with Nintendo 64, well, the internet was not even a thing to be considered. The best thing we could do was connect with a wire to Nintendos and play. That was completely out of the realm. And now, of course, it's kind of weird to think that we're not connected to the network to get updates and all how video games are working and esports are working. So it's international by its own nature. It's of course very technical and specialized. You already saw all the things that Leonid was telling us in the realm of IP. It gets complicated in many other ways, and the industry by itself is a very specialized one. So you need to be specialized, and you need specialized people helping solve the disputes. Then, of course, the product cycles, and Alexia will explain this more within, but of course, in the realm of many of the industries that involve IP, as you can see in the next slide, these are all considered issues that you have to start talking to stakeholders. So we have meetings, and if you could go to the next slide, Alexia, and then I'll give you the word. But all these recent developments have brought us to sit down. And the next slide, please. And to sit down and say, like, okay, we need to talk to people in the cultural heritage, in fashion, in film, and start tailoring procedures the way that will allow us to actually be efficient at solving disputes. Particularly, I am quite focused on the digital copyright and content, working very closely to the implementations of the EU directives and the EU regulations, seeing the focus on ADR that is being there, like promoted there. And we are working very closely on how to develop systems that respond to those considerations of being fast, being digital, being cost effective, and actually relatively, I would say, even cheap, in a way of solving disputes and lowering the access barriers to really enable the environment, at least the digital environment, to move along. So with this broad spectrum of what we do, these are all the areas we're working on. And of course, the last one but not least is video games and esports. I thank you for your time, and please, Alexia, now you can illustrate us on what we're doing.
Can you hear me?
Yes.
Great. I seem to be having a trouble with my camera, but I hope. So following to what Oscar mentioned, and as overview of the different sectors that the WIPO specializes in, I will do.
I think we're having a bit of trouble with Alexia's connection. Alexia, are you
Yes,
there?
hi, sorry, I'm back. My Zoom keeps crashing for some reason, so I'll just bear with me for a moment and I will share my screen straight away. Can you see my screen now?
Yes, perfect. Thank you.
Thank you, Ellie, and apologies once again. So I will, without further ado, I will delve into the specific sector that is of most interest to us today. So I will say a few words about WIPO ADR services for video games and esports. Oscar has highlighted a little bit why do we decide to put together tailored procedures for specific sectors in general. So these reasons more or less apply to the video games and esports industry in particular. So costs and time saving is always important, whatever industry we are talking about. Short product and market cycles. This is of particular significance in the area of esports competitions, which, as you may know, gamers or not, may take place within a few hours up until a few weeks. So we really need to put in place proceedings that will allow for the resolution of disputes within this time frame. Confidentiality, as Oscar illustrated, is important whenever we have to do with sensitive rights and intellectual property rights, and in particular, copyright are such rights. Internationalization, this has a significant essence or value, if I may put it like that, in the area of video games and esports competitions. Mainly taking into account that large competitions, some of which were mentioned by Leonid as well, attract viewers and players from around the world. So an esports team, for example, may comprise players that do not even know each other, that are based in different countries and only meet online. So there is an inherent international element within esports teams as well. And when it comes to viewers, this issue can become even greater, taking into account the streaming platforms that are prevalent in the field nowadays. And allow for competitions to be broadcasted across the world. This internationalization in turn may lead to legal issues such as conflict of law issues, multi-jurisdictional litigation, enforcement across borders. So there was a need to put together a procedures that would help us deal with these issues as best as possible. Video games and esports disputes are also technical and specialized. This can be said for many sectors that involve tech-related elements, but more so here, where we have a combination of tangible and physical elements, such as the gamepad, for example, or the console that is being used for a person to access the video game, and intangible elements such as intellectual property rights, software, IT rights, etc., etc. So this is a quite sui generis field that comprise physical and non-physical elements. And that said, disputes that may arise in this field require particular handling. And last but not least, another peculiarity of this sector that made it more necessary for tailored proceedings is also has to do with the parties that are involved in such disputes. I already said that parties may be based in multiple jurisdictions, so that is one thing. The other thing is that when we talk about parties in an esports dispute, for example, we may talk about an individual who is underage up until a large publisher or a large publishing company. So there may be here a structural and inherent imbalance that we need to overcome as much as possible. So taking all these considerations in mind and keeping all these considerations in mind, we tried here at the WIPO Arbitration and Mediation Center to put together an ADR service tailored for disputes that arise in the video game and the esports industry. When we talk about ADR services, we mostly talk about mediation, arbitration, expert determination. Oscar already implied these proceedings above. So these are basically the proceedings that we use in every sector and every industry, but we have tried to tailor more or less for the needs of the video games and esports disputes. For example, we put together specific rules that include the so-called dispute resolution board, which you may see on the slide. This is basically a standing body that will be put together at the beginning of an esports competition, if I may put it simply, and will be competent to handle all disputes that may arise in the context of such competition. This is more or less similar to certain bodies that Leonid mentioned with respect to traditional sports. What we also try to do in the context of these tailored ADR services for the sectors was to put together a list of experts which are specialized in video games and esports disputes. So here at the center, we already maintain the so-called WIPO list of neutrals, which are neutrals who are specialized in mostly in IP disputes in general. So what we tried to do was to create a sublist, if I may put it this way, within that list, which will include experts, particularly in the industry of video games and esports. Oscar already insinuated that all these proceedings are consensual, so we tried to put together and draft certain recommended contract clauses and submission agreements that parties may use to gain access to these proceedings. For example, the tailored contract clauses that we have uploaded on our website may be used in terms and conditions of esports competitions, such as those that Leonid mentioned in his presentation. And lastly, what I would like to highlight about these services for the video games and esports sector is that our rules may apply to all kinds of disputes, commercial or IP-related disputes mostly. So we are part of the WIPO, the World Intellectual Property Organization, and we have an inherent specialization in IP, but this does not mean that our rules and our procedures apply only to IP disputes. To make this a bit clearer, in the next slide, we have included some case examples of the recent experience and we have had in the WIPO Center while handling video games and esports disputes. This serves to illustrate mostly that our rules can cover all four corners of IP, but all four corners of commercial law too. So you can see on the screen contractual and non-contractual disputes, copyright infringement, trademarks infringement, use of IT and software, and especially when it comes to esports, what we have witnessed the past few years is that a multiplication of disputes pertaining to streaming. So unauthorized streaming of esports competitions on various online platforms. I don't think there is a need to read the cases. This is mostly just to have an holistic idea of disputes that may arise, and I believe we will circulate the slides afterwards. So that was in a nutshell for me too. In the next few slides, we have included some useful links for your perusal on WIPO mediation, on WIPO arbitration, and some contact details if you want to contact us and learn more about what we do here with respect to video games and esports, but also with respect to ADR in general. And that was it for me. On behalf of me and Oscar, we would like to thank you for your time.
Thank you, Alexia. Thank you, Oscar. Thank you, Leo. I can see that we have a very Swiss panel here because we finished, you perfectly respected your time. We have 8 minutes for questions. We have had one question in the chat, and I think this one feeds nicely into what Alexia was saying about the list of experts. So the question is, what kind of profile is sought to act in esports arbitrations? Would arbitrators need to be experts in a given game, for example, to be able to decide cheating issues? What is the extent of knowledge of major games played in competitions required generally? I am not sure who is best placed to answer, but I think all of you can offer your own perspective. Should we maybe kick off with Leo?
Sure. I think you don't need to be an expert on a game, on a specific game to understand cheating issues. I mean, there's a lot in forums on Reddit and other forums where you can read about certain problems, or you can just, if you're nerdy enough, you can just read the patch logs and see what kind of bugs have been solved in that kind of game to understand what kind of background there is. So you're up to date with more or less all the competitive games. And I mean, if you understand how cheating works, that is usually something that you can apply to other games. The important point is to understand how cheating and e-doping, so to say, works. And so as to the list, I think this is a little bit up to WIPO if they're creating lists on qualification criteria. But I think that at least what you need to be is enthusiastic about games and esports in general, be it mobile or on a console or on a computer, and understand where it's going and what the main issues in each game are, where the advantage by cheating might be really relevant.
If I may compliment what you said, I completely agree. And one of the things, for example, that we have at the center is that our list of experts is open-ended. So that gives us quite an easy way to manage in case there's something very specific. We are able to find, we have a big network of experts in every domain, including this, that allows us, for example, to be discussing to create a list of experts on esports to be able to deal with this disputes.
Alexia, I don't know if you have anything to add or if
Uh,
this was a comprehensive answer from
It
your
was quite
co-speakers.
a comprehensive answer. If I may add one thing, is that this may be an easy answer in legal issues, but we mostly make these decisions on a case-by-case basis. So as Oscar implied, if there is no perfect fit for the parties from our list, this list is open-ended, so we're willing to go above that and beyond that and search for the candidate that fits the profile sought by the parties in this case. So there is no easy answer basically on the qualifications that one may have.
Great, thank you. That's very interesting. And obviously, thank you so much for the presentations. There's a lot of issues and it was very, very interesting to listen to you. Oh, and we have a new question in the general chat. In cases of sports arbitration, is the confidential nature of the proceedings violated when the arbitral award is sought to be recognized and enforced before the courts? You can just unmute yourself. Great, Oscar, thank you.
Happy to reply to that. Of course, I mean, within the rules or limitations of confidentiality. So legal provisions, like for example, the enforcement of the arbitration award, that makes that the arbitration award ends up not being confidential because you need to enforce it. So that is provided within the rules. So legal requirements, of course, can void the confidentiality of the agreement, of the award, for sure.
And I spoke also, if I may add, to a lot of stakeholders in the last days, and they say that it's important for them that the awards anonymized, but anyways, that the awards become public. They want to have this body of case law where they can rely upon, so that that will of course not violate the confidentiality, but it will of course, on the other hand, offer a lot of transparency if and when such an arbitral court is created.
And this is a discussion that is not only particular to esports, but we have been having discussions similar to other mechanisms that we're developing in the context of, in general, EU IP law ADR, to be able to kind of provide some insights on what is happening while maintaining the confidentiality of the parties.
This is something we keep hearing, by the way, from parties, especially in mediation and especially in the digital environment. For example, recently, Oscar and I was working on a mediation case where the party, who was an artist and was moving against the publisher, wanted to remain anonymous and conduct the mediation only by her pseudonym, the name she was using on stage, which is it's something that we keep seeing more and more, especially in the digital environment.
Yeah, absolutely. That's a very interesting issue in the online dispute resolution world. So very interesting to see where this goes. And we have another question, and I think this will be the last one in terms of time. In case of matters that are of confidential nature, can the confidential advisor give his ruling to allow the same form part of the arbitration proceedings? I am not entirely sure I understand the question. Is this clear to the speakers or not? Otherwise, Benson, would you like to unmute and maybe provide further detail on what?
It is not very clear for me.
Okay, I'm not sure if Benson can unmute.
Can I please
If
ask a
not-
question?
Of course, Sophie, go ahead.
Thank you. Thank you very much. I thought that was extremely informative. I wanted to ask about the practicality of having parties that want to remain anonymous. I mean, how do you square that? I mean, my question really is, does due process require an equality of arms? Should I know who my counterparty is? I'd be very interested in really practical examples of how one deals with that from the institutional perspective, obviously, and what arbitrators are doing. Thank you.
If I may, and I'm gonna actually, there was a conference not long ago about this, actually sponsored by Lalive in that moment, and it's about, there's a big question mark in the metaverse, for example. If we're talking about arbitration there, that people are basically using their handles but you need to have, at least based on the New York Convention, you need to be able to notify the parties duly and have everything in the concept of writing and all those requirements that, as this has been happening throughout the years, they've been getting more flexible and understanding that technology is allowing us to have this and the other way. But of course, the issue of anonymity is a big question mark, and I cannot give you a straight answer yet. And actually, when we got the case that Alexia was mentioning, even though it was mediation, we still were a bit dubious about how we can handle this. Yeah, so it's not a very clear thing, and we'll be very happy to hear your thoughts about that in general.
And if I may compliment Oscar's answer, Sophie, so what was of particular interest to us in that case, it was a mediation case, of course, was that maybe the anonymity shows a bit of lack of goodwill to be involved in this amicable process, you know, especially when it comes to mediation. So this is what made us a bit reluctant to be very receptive to that.
I mean, couldn't you go around the problem by having everybody sign an NDA or something? It sounds to me like that might be because so this way the parties are aware of who each other are, which it seems to me is a fairly basic right, even in the metaverse. And then everybody agrees to a non-disclosure agreement. I don't know if that's something that you've seen. Leo, feel free as well, please, to chime in.
If I can say one last thing, since you mentioned the NDA, the issue in this particular case was that there was a structural imbalance between the parties. So this was the reason that the artist wanted to remain anonymous in fear of repercussions by the counterparty. So I'm not sure the NDA would be of particular use in that case. It was a bit of a peculiar case, so to speak.
But I think that it might be possible to appear through someone. I mean, you don't need to be appearing yourself in the hearing. And
that was more or less the way we were going to handle it. But to be honest, and this is it's a different case. It was based on the NFT platform. But one of the things that in this environment, and I've been involved a bit on all the crypto thing when it started back in the like really crazy in the 2017s, 18s. The parties collaborate in this environment, but it doesn't mean that they know each other or they want to know each other.
They don't at all. Yeah, they don't.
And sometimes they don't even want to know each other.
No, that's true too.
So it's a bit of a difficult. If you could have the NDA when they start the collaboration and then we include everything there, or in the terms of conditions of the whatever blockchain 2.0 platform they're developing, maybe. But later on,
at the very outset, yes. You're right. That makes sense. Thank you. I'm going to stop taking the floor now.
I got a message from Benson in the meantime, who was trying to unmute. Can you maybe try again, and then I think we will conclude the session. Okay, not sure it's working. I have one last concluding question. And Benson, if you manage to make your mic work, there we go. Okay.
Hello.
Yes, we can hear you.
Yes. Can you hear me? Okay, I was talking regarding the arbitration advisor, because I remember I had the other webinar in which we informed that there is this what we call a confidential advisor, in case if the parties in the arbitration proceedings are having dispute on what should be disclosed during the arbitration proceedings. Usually they have to call the confidential advisor, who will come and then review the issues in the arbitration agreement. I mean, in the contractual agreement, and then upon satisfying himself that there's no any material issue to be disclosed during the arbitration proceeding, then he may proceed, allowing those issues to be discussed during the arbitration proceeding. Now, I wanted to know if it's a similar case in the eSports arbitration. This is what I actually wanted to know.
Great, thank you so much.
To pick up on Benson's point, I think also this is something peculiar, I think, to American ADR, and you see things like special masters where they're called in as a kind of a referee in terms of evidence and disclosure obligations. And actually looking at the documents without showing them to the other side and making that specific decision. So I think that's what Benson is trying to ask about.
Great, thank you so much, Sean. Do any of the speakers have experience with this? Would you like to comment? Or
I don't have any experience with this. I don't know whether maybe in document production, but this is something that in esports would be really seldom would apply. But yeah, I don't know, to be honest.
I mean, the closest that we could have is, for example, in our rules, you allow for private meetings with the mediator if you want to disclose things that you don't want the other party to be aware of, but that would allow you to find a common point, and that we call it caucus, and is basically, I want to just disclose this without the other party knowing. That's the closest I would see in mediation, that we actually see it quite often in our mediations, and it allows the parties to unblock some negotiation point that they don't want to disclose, but the mediator, knowing both parts, can actually find a way to drive them into a settlement.
great, thank you so much. I think we will conclude as we are running over time, unless Benson, you had something to add. I see you unmuted yourself.
Yes, understood. Thanks.
Yeah, sorry. Okay, so I will conclude the session. Thank you again to our amazing speakers for your time and for sharing your knowledge. I have learned so much today, and I'm sure that the same goes for our audience. So thank you so much. Everyone mentioned that they are happy to share the slides. So ArbTech will share them on our page, if that works for everyone. And if you liked today's session and if you want the slides, make sure that you follow us on LinkedIn. I had sent the link earlier in the general chat. And we also have some interesting webinars coming up. We have one coming up in July, so we will be sharing more details on that soon. Make sure you join us. If you have any ideas or if you want to get in touch, do not hesitate to contact us. There is a form on the website, so you can share any ideas, any remarks that you may have, or you can contact me or any other member of the moderating team on LinkedIn. And thank you all once again for being here with us, and have a nice day, afternoon, evening, depending on where you are. And I hope to see you again for the next ArbTech webinar.
Thank you.
Thank you so much.
Thank you. Bye.
Bye.